I have a lot of stuff to cover, so I'll jump right into it. And I know that you guys don't want me to cut into your lunch break. So what this topic is primarily going to cover, we're going to go through a couple things, the statistics of drug use in America. We'll then jump right into substance abuse issues and drug testing and counseling. And then we'll get into some mental health issues and some things to look forward to or look into. And we'll look into reading the DSM-5 and the 5 axes as it relates to that. And then we'll wrap up with some custody arrangement ideas, some tips as it relates to dealing with your client who has those concerns and issues versus the opposing party having those concerns and issues. So to begin with statistics, 25% of adults between 18 years and 25 years old are illicit drug users. So chances are with these statistics, you probably have a client who falls in this category of substance abuse, whether they used to be a substance abuser or are currently a substance abuser. The U.S. Is the world's largest consumer of cocaine. The U.S. consumes 60% of all drugs worldwide. So we're talking meth, heroin, marijuana, PCP, LSD, just to name a few examples. We also consume the vast majority of opioids, which we'll learn that opioids are the thing right now. That's the opioids are what's being abused mostly at this time. As that's the trend. And the majority of the misused prescription opioids are coming from legally written prescriptions. And so now physicians are turning to a drug called Suboxone, which is a drug that is used to help treat pain addiction. But go figure, now that there's some concern and some criticism to this drug, Suboxone, that may be something that's also being abused. So you want to be aware of that coming up with whether it's your client or opposing party. Additionally, 27% of adults 18 years or older have reported that they've gone binge drinking in the last month. And binge drinking is defined as 4 or more drinks for females and 5 or more drinks for males at a given time. And I'm sorry? At a given time. So 4 or more drinks on each occasion for females and 5 or more drinks on each occasion for males. And heavy drinking is defined as binge drinking on more than 5 days or more in a given month. Now, identifying substance abuse problems. So for alcoholism, what you really want to do is ask your client some of the following questions. How many times have they drank in a given week? How many drinks on each occasion in that given week? Additionally, you also want to ask them how much money have they spent in a given month on alcohol. And I'll give you an example of how important that question is. I had a case where we were at a temporary orders hearing, and my client was being cross-examined, and he was being a bit slippery. He was being evasive as far as how many drinks he's had in a given week, in a given month. And so the judge stopped the cross-examination and asked him, how much do you spend on alcohol in a given month? And it stopped my client dead in his tracks, and he thought about it for a little bit, and I could just tell he was just thinking of some off number, and he just threw out $120 per month. So the judge broke it down and said, okay, $120 per month, about $12 for a 12-pack, 10 12-packs in a given month, 120 beers in a given month. That's an average of four beers per day. So the judge didn't like that at all. And I knew when he gave that number that he actually probably spends a lot more. So this is very important. It's very important that you ask that question early on in the case. And this was a temporary orders hearing that came pretty quickly. So you want to make sure that you're talking to your client and asking your client early on. You want to make sure to try to get bank statements, credit card statements beforehand in your early meetings before you get to your initial court appearance. Because a lot of these issues are going to be issues that come up early in your case. And so they come up as you're going into your initial court appearance. Because by the time you get to trial, all of this should have been discovered. There should be treatment, et cetera, that has already taken place. So this is, the context of this is really early on in your initial consultation, your initial meetings with your client, and before your first court appearance. Ask your client, have they ever been arrested or pulled over? So any public intoxication charges, any DUIs or DWIs, and how many, how long ago? There's sometimes there are cases where we have a client who has a DWI, but maybe it was from 5 years ago, 10 years ago, and there haven't been any issues up to this point. So you want to make sure you figure out how remote these arrests or charges, are there any charges pending, were the children involved? Much like the cross-examination in the previous presentation, drunk mom driving the kids to school. So you want to make sure if there are children involved, were the children involved in any of these arrests or charges. Additionally, you want to ask if the family has expressed concern. Have they had any interventions in the past? For example, we had an opposing party who was an alcoholic, and thankfully, my client, her husband, had a great relationship with mom's sister. And unbeknownst to mom, we were able to get mom's sister to testify on our behalf at the temporary orders hearing. And the look on her face when she came in to testify on our behalf, it was priceless. So that is something that you certainly want to look into. I mean, it's a gem for you to have if you're dealing with an opposing party who has that issue and you have family members who want to step in and help that opposing party. It'll help your case if you have that information ahead of time. Regarding illegal drugs, any use is bad use. So you certainly want to discuss any of that with your client. Another question is, did they use knowing that they were going to be into court soon? So for example, I had a colleague who recently had a case where none of the initial pleadings filed by the opposing side requested any kind of drug test or alluded to any kind of drug issues. It was all related around alcohol abuse issues. And so leading into the temporary orders hearing, my colleague had no idea that drugs were even a problem. None of that ever came up in initial discussions with the client. And so a couple days before the temporary orders hearing, my colleague had a conversation with opposing counsel for potential settlement, and opposing counsel indicated, well, we want to drug test your client. So that my colleague took a step back and said, okay, well, I'll ask my client about it. She asks him, and he says, what? No, I used meth last week. We got to settle. So you want to make sure that you're asking your client about both. If there's alcohol abuse issues, there may be some drug issues lurking in the midst of all that. So you want to make sure that you have that discussion with your client as well. And it's one of those things that it's a problem, especially if they knew going into a temporary orders hearing that may be something that comes up and yet they still used. I mean, there's a problem there, and they need that help. You want to test before the court does. So in that example, that is something that if it has come up and you discuss with your client, if these issues may come up, you be the first to ask your client to go do a urine test, a hair test, a nail test. Discuss with them the costs associated with that. You want to make sure you get those results and figure out, are you going to come up positive for any, if it's an alcohol issue, an ETG test. And we'll talk more about drug testing and alcohol testing and the various types of tests. But you want to be the first to do that rather than the court. And you want to use that for your strategy going into that initial court appearance. And you want to make sure, again, you do both a urine and or a hair or nail test. A urine test is going to be for more recent use, and your hair and nail tests will be for more, how far back does this go, this drug use or alcohol use? So you want to be sure to have those strategy discussions with your client and use them on, okay, well, whether we have to settle before we go into our initial court appearance and get the best deal that we can, or if you can push through that initial court appearance and that temporary orders hearing. So in that example that I gave you with the methamphetamine use that happened the week before a temporary orders hearing, we settled for the best that we could without going into court. So that's why it's important that you do the testing before the court does. Because if it's an issue, the court is going to test your client or potentially both parties. For prescription drug abuse, this is going to be harder to identify. You want to ask your client how often that your client or the opposing party renews prescriptions. You want to ask whether they're taking medication for more than one ailment in the last month, in the last year. You want to ask if they're getting more than one prescription from more than one doctor's. And you want to ask your client to see if they're filling prescriptions at more than one location. These are all things and tendencies that these clients or opposing parties will try to do to help fix and get their fix for that addiction. It's a disease, it's an addiction, and so you want to fully vet your client before that initial court appearance. Here are some helpful resources that you can look into early on. The first is a substance abuse subtle screening inventory, otherwise known as SASI. The SASI is a brief self-report. It's an easily administered psychological screening that can be done by a counselor, for instance, and the screening can be used for adults or adolescents. Adolescents being from the years 12 to 18 years. So it's a simple and efficient way for you to get an answer for further evaluation or for further treatment by the counselor, if there is a counselor involved. And if there's not a counselor involved, it's a way for you to identify if they need to go seek counseling and get into treatment early on. Another resource is the National Institute on Drug Abuse, otherwise known as NIDA. It provides helpful information for various screening methods. There's a link here for those various screening methods that you can take a look at. NIDA also provides helpful articles for emerging substance abuse trends and alerts. As I indicated, right now the biggest thing that's being abused are opioids, which again are very difficult to identify. Alcohol screening, here's some various methods for alcohol screening. So to begin with, you have ethanol alcohol testing, and ethanol has a relatively short window of detection in urine, and so the normal clearance of ethanol from urine is 8 to 12 hours of use before the testing. ETG testing is another alcohol screen. And ETG testing can be detected in urine up to 4 to 5 days after alcohol has been consumed. And so that's another way of screening alcohol. There's also ETG hair testing, which will test back further than the urine sample. Another alcohol screen method is alcohol swab. That will test back. It'll test a person's saliva. It'll test back roughly 12 to 24 hours. It's highly accurate for very recent alcohol use. The problem here that you want to be aware of is the practicality of use of these results. You obviously don't want to be carrying around a box full of alcohol swabs into court, so the practical nature of it is not as good as SoberLink, for instance, and we'll talk a little bit more about SoberLink. But the alcohol swab can be helpful because there are occasions where the SoberLink mobile device or some other mobile device can allegedly malfunction if it's tied to immediate use before visitation. And so we recently had a case where a mom alleged that her SoberLink device malfunctioned and she was heading into her visitation. But thankfully, the supervisor had an alcohol swab test kit that immediately tested mom. And of course, she popped up dirty. So it is helpful in those situations where it's immediately needed, but long-term, the practical nature of an alcohol swab is probably not the best. Then you also have blood spot testing. That's just sticking the person's finger and getting a blood spot test. The good thing about a blood spot test is that it'll test back 2 to 3 weeks of alcohol consumption. So if you have that concern, that time frame, it's helpful in that way. And then another method is SoberLink and other breath alcohol concentration tests. And these will test roughly 8 to 12 hours of consumption beforehand. What I really like about these devices are that they're mobile. You can test anywhere. You can tie it to visitation. And so I really like to use SoberLink. Here's a link for it. And so it's an efficient way to do it. It's great for reporting. It's great for using those results in your upcoming hearing. And the other good thing about it is that these results, you have a couple of options. One option is the results can be emailed to your client real time, though a lot of clients may not be checking their email as these results come in. Or you can do a SoberLink app or other mobile device app, and that'll come in real time like a text message. So if there's use that came from that result, what I like to do in my visitation schedules is that if there's a positive result, that visitation will immediately cease. So that's why I like the real-time result on a SoberLink or similar device. You want to make sure that you talk to your client about. So if your client has the issue and you recommend SoberLink, you want to talk to them about the cost associated with these devices. There is an initial cost for the actual device itself, and that's roughly $300 to $400. And then there's a monthly cost associated with the use of that device that you want to talk to your client about. And the monthly cost can differ between, I think it's between 20 and 21, 25, roughly 20, 21 uses in a given month, which is typically tied to a visitation schedule. Or it could be, you can get a plan that tests daily in a given month. So you want to walk through your client with all those options. And you want to make sure that you ask for and you get releases for any potentially protected health information. I know in Texas, my jurisdiction, these drug test or alcohol test results are protected health information. So you want to make sure that if you're at a temporary orders hearing and you're asking for these testings, that you also include in your order the request for the release of this protected health information. Testing and counseling. I've already mentioned that you want to make sure that you drug or alcohol test your client before you get to court. You don't want to have your client admit on the stand that there is that issue, drug use or alcohol abuse issue. You don't want your client to perjure him or herself on the stand. So that's why it's very important that you discuss that. As I stated before, they will be tested if there's any kind of allegation as it relates to alcohol abuse or drug use. And so you want to make sure that you discuss that early on with your client. In all likelihood, if there's allegations on one side that the opposing party is an alcohol abuser or drug user, you really want to take a close look at your client, because if one party uses, it more than likely both parties use. And so you want to make sure that if your client is asking for alcohol abuse or drug testing on the other side, that you just cover your bases and you say, well, you should do the same if we're going to be throwing out those allegations. Now, if it's the opposing party who has the issue, you want to make sure that you ask that the opposing party be tested right away. Now, in all likelihood, before you get to your initial court appearance, you're not going to really be able to force that unless there's an emergency setting or an emergency order. So at your temporary orders hearing, you want to make sure that you ask the court that the party be tested right away. So for instance, I've had judges who will, as soon as the hearing is over, they need to go get tested. So if you can do that, that's going to be best than if on some occasions courts will say you have until the end of the week, or you have 24 hours or 48 hours. So you want to make sure that you ask for immediate testing. Additionally, if they give them a few days to test, you want to make sure that you ask your court to either do both a urine and hair or nail test, or just go straight into a hair or nail test, which will test back further than urine, to make sure that you cover all that time frame if the judge is giving them several days to test. You want to make sure that you discuss with your client to take, so if your client has the potential issue and they're taking any kind of prescription medication, you want to make sure that you advise them to take all their prescriptions to the testing facility. I can't tell you how many clients I've had come in and we get a result that says methamphetamine positive, and they want to try to explain to me that it's because of their depression medication or some other medication that they're taking. So you want to constantly remind them to take all their prescriptions and disclose all of that to the testing facility, so that the testing facility can account for the potential for those prescription medications to pop up. Have the children been exposed to any of the drug use? Obviously, if that's a concern, and it's a concern that the opposing party has exposed the children to this drug use, if there's a non-invasive way to test the child or children for potential drug use exposure, you can have your client do so. But you want to be sure, because drug testing can be pretty evasive, and if you're not sure and it doesn't come up and the other side figures that or finds out that you used an invasive procedure to test that child, it may not be good for you and your client. So you just want to be sure you do have that ability. Your client does have that ability if there are concerns that the child may have been exposed to drug use. I'll give you an example. I had a case where the opposing party was a meth user, used meth in the home, and there was suspicion that the child was exposed to this meth use. CPS had gotten involved, and they tested dad. He came out thankfully negative. Mom refused to test until a week later. So thankfully they put a safety plan in place to put the child in dad's care. However, they tested the child, and the child came up positive for meth. And this child was 3 years old at the time. So if there are concerns, you want to make sure that you also ask for the testing of the child, because that can be a slam dunk for your case if the child ends up being unfortunately exposed to drug use. What treatment and counseling has been done or what needs to be done? So you want to make sure that you talk to your client about doing these things, whether it's treatment, rehab, counseling, doing these things before your initial court appearance, because that's going to be the best strategy for you. If you know that this is an issue, it's going to be best to just take responsibility, but get into the treatment, get into the counseling before you get to your initial court appearance. So if there's rehabilitation that may be needed for drug use or alcohol use, it's always going to be better to try to do some sort of outpatient treatment so that your client can continue to maximize their time with the children. If it's AA, Alcoholics Anonymous, you want to make sure that your client has the attendance record for those weekly or bi-weekly meetings. You want to make sure that you talk to, that your client has a sponsor, that you talk to the sponsor, and if the sponsor is a good witness, make sure that the sponsor will be able to advocate for your client in court. If your client needs to go to counseling, you want to make sure that they get into counseling and that you keep in contact with the counselor as far as how the treatment or how the counseling is going. Because if they are helpful, you want to make sure that counselor is going to be able to go in and testify at your initial court appearance. You want to make sure that you talk to your counselor frequently if your client does get into counseling, because I've had a conversation with a counselor before and said, hey, how are things going? And my counselor says, your client is a mess. All right, forget that subpoena, and we'll be done, and then we'll strategize accordingly. So you want to make sure you're talking to that counselor before your initial court appearance to see whether they're helpful or whether they're not going to be helpful, because again, that will help in your strategy, in your approach to your initial court appearance. Understanding your drug tests. So obviously one of the questions that you want to ask yourself is urine or hair testing. You also want to keep in mind nail testing, which is going to be very similar in terms of how far back it tests to your hair testing. So you want to make sure, as I mentioned before, to get both from your client before your initial court appearance, because again, urine testing will test for more immediate use, and then you want to gauge how far back the alcohol or drug use occurred with your nail or hair test. Creatinine levels, the thing that you want to be aware of for creatinine levels are a normal level for female clients is between 100 to 150 milligrams per deciliter. And then if you have a male client or opposing party, it's between 150 to 200 milligrams per deciliter. Now, a diluted specimen that you want to look at, if you find that in any of your testing results, you'll see whether it's both male or female, the cutoff level is going to be 20 milligrams per deciliter or less. And a diluted specimen is if somebody who's in all likelihood drank water in excess to flush out the drug or alcohol use. And so that's going to be a huge red flag on your testing results if you see a diluted specimen. And if it's your client who's trying to dilute the specimen, judges have seen this on many occasions. So you want to make sure that you talk to your client that they shouldn't be doing that, because in all likelihood, the judge is going to interpret that testing result as a positive testing result. Because again, judges know what they're looking for. And if not, if it's the opposing side and you get a diluted specimen, make sure that you educate your judge and reiterate what a diluted specimen is. Because in all likelihood, they're trying to flush out that drug or alcohol use. One thing that you should consider doing if you have a temporary orders hearing and you want the opposing side to test, make sure you try to get the court to order the opposing side not to drink excessive fluids or liquids before the testing. Now, some of you may be thinking, well, what's the practical nature of it? The reason for that is because you want to put that in the judge's mind that if there's a diluted specimen, that's arguably a violation of the court's order not to dilute the specimen. So that's one way of trying to get ahead of that and ask for the court to order that ahead of time. You also want to make sure that if there's any future testing, which there should be, that it be random. Now, for hair testing, what you want to keep in mind is that there are going to be higher levels of creatinine in the body hair versus the scalp hair. So if your client has the alleged issue, you want to make sure that your client you advise your client to use head hair versus any kind of body hair. Because a lot of times, if you haven't had a client with this issue and they get ordered for hair testing, a lot of times they'll try to shave their head and think they're good. So you want to make sure that you advise your client that they'll use your body hair, and that's going to be worse off than your scalp. If the opposing party is being tested, one thing that you can ask the court to do is is ask for an injunction against any kind of cutting of the hair, coloring of the hair, bleaching of the hair, stripping of the hair, because those are all things that can affect and impact the testing result. So make sure that you ask the court to, one, acknowledge on the record what their hair looks like at the temporary orders hearing, and then two, ask for injunctions against those things. Because again, those are things that these clients, these parties will Google to try to see how they can beat these tests, and those are all different ways that they can try to do that. There's also certain shampoos on the market that can impact those testing results. So if you suspect that may be something that comes up, ask for a nail test, because again, that's another effective way to get these results if the opposing party has the issue. I've done this in court before, and I've asked the court to acknowledge on the record what their nails look like at the time of the temporary orders hearing. So make sure you put that on the record and put that in the judge's mind as far as whether there's any kind of, what their nails look like. So that way you ask for any kind of injunctions against polishing or clipping of the nails. And it could be both the fingernails and the toenails. So if the fingernails don't look like they would provide a good specimen, you can ask the court to order toenail testing as well. As far as the different types, and as far as the fingernails will test back 3 to 5 months approximately in terms of detection, and then the toenails will test back further approximately 8 to 12 months prior to that testing date. As far as the different panels that you can request, the biggest takeaway there are you want to make sure that the panels you're requesting include the drug tests or the drugs that you have a concern about. So that's the biggest thing with the different types of panels that you want to take away, whether it's 5, 7, 10, 12, etc. You just want to make sure that the drug you're concerned with is included in that testing. Metabolization, what you should understand there is that most tests won't show methamphetamine or heroin or the actual street drug name. So you want to make sure that, for example, methamphetamine when tested will often come up as amphetamine, or heroin will metabolize into morphine or opiates. Cocaine, and I won't even try to say the benzo, this scientific term, but it metabolizes into benzo or norcocaine or coca-ethylene. So when you're looking at a drug test result, you want to make sure that you understand what is actually being tested and what's related to this street drug. Now, if you do have anything that comes up and it shows positive and you have no idea what that scientific term is, you can call the testing facility and ask them yourselves. There's been plenty of times where I've called a drug testing facility and they've been more than happy to help explain what the results are. So if you have any questions regarding any positive results, make sure you call and use your resources, including the drug testing facility. Now, this chart is just a reference for you to take a look at as far as levels of usage in hair. One of the takeaways here, I had mentioned milligrams to deciliters before. This chart shows picograms, and it'll be to deciliters. So you may see both types of results, and that's what this is in this chart. It's a five-panel hair test. And it shows you low, medium, and high usage. The biggest takeaway regarding the marijuana entry there is that although it is difficult in terms of detecting marijuana in hair tests, it's not impossible. So that may come up as well in your hair testing. So the question is, for marijuana, whether you can detect, but can you detect when they used? And that's the difficult part with marijuana, is that it's qualitative in nature, so it's not like these other drugs where you can see how much of the marijuana has been consumed, whether it's high usage or low usage. It'll just show whether it's been used, and it's difficult to detect how far back, so when it was used. But the biggest thing there is arguably it was used, period. So you still want to use that to your advantage in your cross-examination, and tie in the results in your cross-examination, and then tie in your client's testimony on direct, because they should have some idea of when that marijuana use took place. Hopefully your client doesn't have any of that positive result, so even a positive result to marijuana can be used to hopefully get a custody arrangement in your favor, if your client is clean otherwise. Now I'm just going to go through a couple of quick reference guides that you have in your hands, and you'll be able to take away. So these are just different detection times after usage in urine. So that's just going to be a quick reference guide for you guys to have and take with you. The same thing for the next slide, showing drug detection periods. It's another quick reference guide. This shows blood, saliva, urine, sweat, and hair samples. But don't forget, in conjunction with or in addition to your hair sample, nail tests are also an effective way to get the results that you want. And especially, we had a client who was ordered to nail test, and he had just so happened to shave his entire body, claiming that he was a swimmer. And so we went back in, and the court ordered him to nail test. So you don't want to forget about your nail tests as well. Now these next few slides are going to show different examples of drug testing results. These next few slides are going to show 5-panel hair test, and the first result that you see here is a high positive reading for cocaine use, and the date on this result is from June 2009. You'll also see positive results for, as I mentioned in my previous slide, that benzo that specimen. That's a major metabolite of cocaine. Then you also have norcocaine showing positive. That's a minor metabolite of cocaine. And then you have coca-ethylene that came up positive as well. And that's something that's formed by the liver when cocaine and ethanol coexist. So that's why on this result you see all of those positive results. And so this is just an example of what you may see in your different types of drug testing. Now, the purpose of the rest of these slides are going to show really a goal of what you, hopefully, if your client, well, hopefully you don't have a client who has these cocaine issues, but you probably do. But if you do have a client who has these issues, you want to see these results, as I'm about to show you, where you have a high level of usage, and then you're going to see it slowly decrease as we go through each of these different samples. So this next result, same client, 5-panel hair test, and this is a lower positive result a couple months later in August 2009. And then this next slide shows it going lower positive result as of October 2009. And then the next one is November 2009, again, a lower positive result. And then finally, you have a really low positive result for cocaine as of January 2010. So that's, if you have a client who has that issue, that's the trend that you want to see in these drug testing results. And so then the idea is that once you've gone through that and your client then no longer is testing positive for cocaine, modification time, and you want to make sure that you immediately get in there and show that your client is abiding by the court's order to abstain from drug use and is on the right path. So in conjunction with the drug testing, in all likelihood, they're going through treatment and or counseling. So this is really what you want to see as you progress in your case and as drug testing is ordered in your case if your client has the issue. And the flip side of it is if the opposing side has the issue and there are children involved, I mean, this is also a good thing to see, is that they're on the right path, because the children do need both parents, healthy parents in their lives. So now we're going to transition into identifying mental health issues. So firstly, 1 in 6 Americans suffer from some sort of mental illness. So you want to make sure that you ask your client about any kind of diagnosis or medications. Now, raise your hand if you have a client who's come in and said, well, my husband or my wife is bipolar, right? I mean, we probably all have had that client come in, and then you ask them, okay, well, can I see the diagnosis, or who diagnosed, or is there a diagnosis? Well, no, they have to be bipolar. They're crazy. So make sure that you're asking if there's actually been a diagnosis by a mental health professional. Ask them. You want to make sure you ask your clients if your client or the opposing party has had a DSM-5 diagnosis, and we'll talk a little bit more about what DSM-5 is. But that's something that you want to ask your client early on, is if they or the opposing side has had a DSM-5 diagnosis. Discuss all medications that your client or the opposing party may be taking, and how long they've been taking that medication. Are they currently seeing a counselor? So whether a psychologist or a psychiatrist, how often are they seeing this counselor? And why are they seeing this counselor? Just because they're going to therapy or counseling doesn't necessarily mean that they have a mental health issue. So you want to make sure that you're asking, why is it that they're going to counseling? Sometimes they just may be struggling with the divorce process or just some other personal issues. So you want to make sure that you discuss those things thoroughly. Were they or are they in any treatment, or have they ever been hospitalized for any kind of mental health issue? Now, I've had plenty of clients come in and say that they have gone to detox and they're good. They're free and clear of drug testing or alcohol abuse issues. Detox is not treatment or hospitalization. Detox is just, it's one potential way of trying to be relieved of that drug or alcohol abuse. However, it's not the solution. It's not treatment in and of itself. So you want to make sure that you discuss that with your client as far as detox not necessarily being the solution to these issues. Have there been any arrests, not just convictions, but have there been any arrests for, again, DWI, DUI, public intoxication, or some other prescription drug or other drug use? So you want to talk about any arrests and not just the convictions. And ultimately, you want to use your instincts. You should be able to tell if there's something pretty significantly wrong with a client as you meet with your client initially. I'll give you an example. I had a case where in my initial meeting with this client, it looked like he had just brushed his teeth with cocaine. I mean, this guy was just so off, and I could tell right away. So use your instincts. You should be able to pick up on any of these issues, and we'll talk a little bit about not judging them, because that can be offensive. So we'll talk a little bit about how to deal with these clients who may have mental health or drug issues. But again, just because they have questionable behavior doesn't mean that they're mentally ill. So if they have a counselor, make sure that you're talking with that counselor to see to what extent there are any kind of mental health issues. And another thing that you want to keep in mind is that they may be suffering from more than one mental illness. And so we're going to talk a little bit about that in this next slide, reading the DSM-5. What's the DSM-5? It's short for Diagnostic and Statistical Manual of Mental Disorders. It's the 5th edition. It has 5 axes, and this manual is used primarily by psychiatrists who will do psychiatric evaluations. Some psychologists will use it, however, they may not necessarily do a DSM-5 diagnosis. And you want to keep in mind that it's a guidebook for psychiatrists. So it's similar to what we use our rules of civil procedure in our law practice. And you also want to keep in mind that it's not a test that's administered. It's not like the MMPI or the MCMI or the PAI. It's not a test that's being administered. And it also isn't something that will provide you with guidelines for treatment. However, it is helpful in measuring the effectiveness of treatment. So it'll help clinicians assess whether there are changes in the severity levels as a response to that treatment. So again, it's used primarily by psychiatrists who will make a diagnosis for certain mental disorders. And I have a list of the 5 axes that the DSM-5 covers. I'm going to skip to, I'm going to cover axes 1 and 2 in the additional slides that are coming up. So I'm just going to jump to and touch on axes 3 for now. And axes 3, what you want to take away there is that these disorders are disorders that can change over time and they can be treated, and so the severity levels can go from high to lower. So those are things that can change. Another takeaway is that these disorders on axis 3 are something that can contribute to a person's mental well-being. So for instance, a disorder like cancer is something that can really affect a person's mental health. And that will fall into the axis 3 diagnosis category. Axis 4, contributing social stressors. So for example, homelessness or divorce cases. So all of our clients are pretty much going to have an axis 4 diagnosis because the process of divorce can be a social stressor that contributes to their mental well-being. And these social stressors could be a cause for a psychotic breakdown. And it could just be a small window of a psychotic breakdown. I'll give you an example. We had a case where our client hadn't really had any kind of mental health issues leading into the divorce. The divorce was filed, big custody battle took place, and this client just went off the deep end. He had this psychotic break. And thankfully, we had a psychological evaluation that had this diagnosis and indicated that this instance, these issues that came up are all a cause of this lengthy divorce and this custody battle that took place. And thankfully, he hasn't had any kind of relapse in that issue. Again, it was just that axis 4 diagnosis because of this divorce. And so thankfully, now that we've closed divorce, we haven't had any phone calls with any issues since then. So that's an example of what an axis 4 diagnosis can look like. Axis 5, level of functioning 1 to 10, or 1 to 100, 100 being no problems, and 1 being immediate harm to self or to others. So 1 would be something like immediate commitment to or hospitalization. You may not see a DSM-5 diagnosis too often. It's just one of those things that if it does come up, you want to be aware of, well, what is this? So if you're looking at that range of 1 to 100, you want to understand what you're really looking at in terms of that diagnosis. And so ultimately, why is it that we really need to read and understand a DSM-5 diagnosis? Well, in all likelihood, again, 1 in 6 Americans suffer from some sort of mental illness. Mostly all, if not all of our clients are going to have an axis 4 diagnosis because of a divorce or custody battle that's looming over them. And so you want to make sure that you understand who you're dealing with, who you're working with, and how to approach that client. And so that's why it's important to have an understanding. You don't need to be an expert on DSM-5. You just need to have some sort of understanding of what type of client you're dealing with and how to approach your client. So these are just some examples of Axis 1 mental disorders. And the takeaway that you want to take for Axis 1 mental disorder is that these are diagnoses where there aren't too many changes in the disorder. So for instance, now there can be some change, but it's very rare in terms of the severity level. So for instance, if somebody's been diagnosed as a schizophrenic, I mean, that's their diagnosis. So these are the types of, these are the types of mental disorders that fall within the Axis 1 diagnosis that you want to just be aware of. And so again, these are just examples. Bipolar disorder, I mentioned, everybody most parties will accuse their spouse as having that sort of mental disorder. So you want to make sure that you talk to your client whether there's been a DSM-5 diagnosis accordingly, or whether some other mental health professional has diagnosed them accordingly. Personality and development disorders, Axis 2. Here are some examples of what disorders fall under an Axis 2 diagnosis. And so the biggest takeaway here, again, are there can be some changes to this diagnosis, but it is rare that there are any changes to these diagnoses. So if you see this Axis 2 diagnosis, you want to be aware that it may not be changing. And so you just want to make sure that you have a full understanding of that diagnosis and how to approach that diagnosis, whether it's your client or the opposing party. And these are just, again, personality disorders continued. These are additional examples of Axis 2 personality disorders. We see borderline personality disorder come up quite a bit. And the reason we do is because it's, substance abuse falls under a borderline personality disorder. So I'll give you an example of a case I recently had. Mom was an alcoholic, and she was pro se. So needless to say, it was extremely difficult dealing with a pro se alcoholic opposing party. And she refused to talk to me on the phone, so I could never talk to her on the phone. However, we would correspond via email, and so with an alcoholic, an email probably is just going to sound like gibberish. There's not going to be too many full sentences. It's just not going to make a whole lot of sense, complete sentences or understandable sentences. But what I was noticing from her emails were that there were complete sentences, but pieced together, they didn't make a whole lot of sense. And then it was just one email from back to back to back to back to back. It ended up being that she had a borderline personality disorder. She ended up being diagnosed with borderline personality disorder. So I was able to pick that up from so again, a lot of these substance abusers will fall under one of these axes or one of these personality disorders. And with substance abuse, you more than likely will see that they probably have some sort of borderline personality disorder. And so why is it important to understand whether they've been diagnosed with borderline personality disorder? Well, one is for the safety of the children and how to approach that. So that's one thing if you do have a case that's dealing with custody. Another thing is just dealing with that party, him or themselves, because there's different characteristics that fall under these diagnoses. So you want to make sure that you understand what that is if something like that comes along. Now, dealing with unreasonable expectations. As I stated before, you never, if your client is the one struggling with these mental health issues, you never ever want to judge. You want to show them that you're on their team, you're their advocate, you're their teammate. So if that's something that comes up, you want to make sure that you show them that. Because again, it's one of those things that mentally, you're not going to be on the same wavelength in terms of understanding this process. Heck, it's difficult enough the process is difficult enough on its own with somebody who doesn't have a mental illness. So that's why it's very important that you don't judge them, but that you have an understanding of who you're dealing with. Additionally, more often than not, somebody with a mental health issue is going to have extremely unreasonable expectations in their case. So you want to make sure that you have that understanding and that you understand that they're going to have unreasonable expectations, and so that you thoroughly walk through that. And I will tell you that in trying to walk through those expectations and setting that tone for the case, they probably won't grasp that throughout the entirety of the case. So part of that understanding is making sure that you protect yourself and your license. And so you're covering yourself, keeping things in writing, and when I'm dealing with somebody with a mental health issue, I'm usually just sticking to communicating with them via email, in writing, because again, they will flip-flop on you and they will say, I didn't give you consent to do X, Y, Z, if you're discussing those things on the phone. So you want to make sure that you keep all that correspondence in writing so that you cover yourself. And it's not one of those things where you keep it in writing for the purposes of saying, hey, remember we had this discussion before? This is exactly what we talked about, and this is exactly what you gave me consent to do. Because it just doesn't register. It's an illness, it's a sickness. So it may not be for the purposes of showing them that this is what we're doing. It's pretty much mostly for the purposes of protecting yourself. You want to strongly advise these types of clients to seek help and to seek help from a counselor, a licensed psychologist, a psychiatrist. Again, courts are going to appreciate this more so if you attack it at the forefront, and if you go into court saying they're going to counseling, they're going to treatment, and then if that counselor is going to be helpful for you, you hire that counselor as an expert to testify on your behalf. So you want to strongly advise your client to get in and seek the therapy and the help. Now, with these types of clients, you want to be very careful, because the suggestion to go in and seek counseling or treatment, go in and see a licensed psychologist or psychiatrist may not go over well. So you want to be creative. Use an emphatic sandwich. So it's like the concept of primacy and recency. You give them the good news first, you give them some bad news, you keep the bad news in the middle, and then you end with good news at the end. So that's a strategy that I use that often does help, is that emphatic sandwich. Use your expert to guide you. So if you do get them into counseling, make sure that you are working closely with your expert in terms of how to handle your client. As much as we want to try to deal with these things on our own, a lot of times it's just out of our expertise. So make sure you get somebody on your team to help you in guiding your client, in guiding the strategy, in guiding the advice that you give to your client. You want to figure out if you and your client can survive a psychological or custody evaluation. More often than not, these clients will come in and indicate, oh, my wife, she's crazy. We got to get her. We got to get a psychological or custody evaluation. Again, if one party has an issue, they both probably have the issue. So you want to figure out if you and your client can survive a psychological evaluation or custody evaluation before you put that in the pleadings. So before you put that in your initial petition, or before you get into the court appearance, you want to make that determination. Because in all likelihood, if you're asking the court to order the opposing side to undergo a psych eval or a custody eval, your client is going to have to undergo the same thing. And so that client who I talked to you about, who I mentioned looked like he had just brushed his teeth with cocaine, he came in asking and saying that his spouse needs to go through a psych eval. And I could just tell just by looking at him that this is not something that we could survive. So you want to make sure that you walk them through the pros and cons to doing that. You want to give your client choices and let them make the decision so that they can ultimately feel like they're in control. With these clients who have mental health issues, the sense of control can put them at ease occasionally. So you give them the choices so that they can ultimately make the decision. Try to guide them through the choices and decisions, but ultimately, if you help them, if you guide them through that and they make that decision, the sense of control will put them at ease. Now, some considerations for the right expert for the job. Here are some things that you want to make sure that you walk through and talk to your potential expert who you get involved and on your case. So specializes in the right area. Are you going to look for somebody who's a general therapist or somebody who specializes in a particular area? And so you want to make sure that you walk through that as well as these other factors. Membership in any professional association, what you want to keep in mind is there any association that they're involved in that's relevant to the issues or the mental illness at hand? With these experts, what you want to keep in mind are expert challenges, of course. So now we're not going to go through the challenges as it relates to the Supreme Court cases of Daber or Kumo Tire, but you want to keep that in mind as well when you're looking for the right expert to hire to help with your client who has that mental health issue. You also want to make sure that you review their resume. A lot of times, attorneys will just take a resume for granted and not really fully vet what's in that resume. I'll give you an example, and this is not necessarily for a psych eval or custody eval type of expert, but we had a case where the opposing side hired an expert. It was a business evaluation, and this expert included an association that didn't exist. And so then that business eval was useless at that time when our expert found that out. So make sure you're reviewing the resume and reviewing and making sure that these associations or affiliations that they say that they're involved in actually exist. Now, as far as psychologists, what you want to consider are whether you're going to hire a forensic psychologist or a therapeutic psychologist. There's a huge difference, and we'll cover a little bit about that, why that huge difference makes a difference. But as far as forensic standards, a good resource for forensic standards is to look at the APA guidelines. If there's a child custody evaluation, look at APA guidelines because that will help you understand whether your expert actually did what they needed to do in that custody evaluation. What you also want to keep in mind is that therapeutic psychologists cannot opine as to whether a parent or the opposing side should be the primary custodial parent of the children or child. So if you have a therapeutic psychologist who's trying to opine as to the opposing party being the best fit parent, make sure you object immediately because that's not their role. That's not they don't have that ability to do that. That's a forensic expert, a forensic psychologist. Now, you may be tempted to want to hire the same expert for the same job. And why would you be tempted to do that? Well, the cost efficiency, right? You want to hire an expert to do the therapy, and then you want to hire them and use them to do the forensic analysis. Don't do that. It actually is more harm than good. One, it shouldn't be allowed. It's impeachable because ultimately it's not the same goal in terms of forensic therapy and therapeutic counseling. So they both have different goals. Don't use the same expert for both. And if you have the opposing side who's doing that, you certainly want to impeach that witness because again, they're not the same. The same goals are not kept in mind. If the other side has the issue, you want to aggressively address that issue as soon as you're aware. I'll give you an example of how, if you don't do that, how that can affect your case. I had a case where it was that methamphetamine case where the child had tested positive for meth. Well, it just so happened that our client had decided to try to reconcile with the opposing side. Now, this was all before he had hired us, but he had tried to reconcile with the opposing side. It was a 6-month period. Well, she decided, I don't want to be with you. And so he came to us and said, we need to file immediately because my child tested positive for meth. She's a former meth user. So we went into the temporary orders hearing, and that was 6 months after this testing had occurred. That was 6 months after CPS had already done their investigation, had already come back, had indicated, well, that may have happened, but mom has really stepped up. We've tested her. She's no longer testing positive for meth. And so this child is doing okay at this time. And that all happened at the temporary orders hearing. And at that time, despite our client not having any kind of drug history issues, he still allowed that child to live primarily with mom for that 6-month period. And so the judge specifically stated that in his ruling, that I think you're just trying to use this for your advantage at this point, and I don't see an issue now, 6 months later. If you would have come to me 6 months ago, after the immediate testing, I would have ordered supervised visits. I would have put the child primarily in your care. And so, in essence, it was a punishment. And it was a difficult situation because at that point, well, what was the judge to do? There weren't any issues 6 months later. So you want to aggressively address the issue as soon as it comes up. And you want to talk to your client about the pros and cons of waiting if your client decides, maybe we hold off. And you address that whether through emergency protective orders, temporary orders, and setting those right away. You request orders for treatment. You request orders for testing, for additional safety measures. And again, you want to make sure that you're asking the court for releases at the time of your initial temporary orders request. So if you're requesting treatment or counseling or testing, you want to make sure that the court also covers orders for releases of all that information. Because what good is the counseling, the treatment, the testing if you're not able to get your hands on it as the case is progressing? Because remember, the context of all of this is that you're initially doing this at the onset of the case in your initial court appearance. So make sure you're asking for those orders as well. You want to make sure that as you get those releases and that release of information, you attack any misstep in failure to follow the course of treatment. A lot of times, these opposing parties, if they have the issue, a lot of times they will skip out on the frequency of counseling. They will stop going to counseling against the recommendations of the counselor. And these counselors will not talk to you without a release from the court or from the opposing party. So make sure you get the releases and make sure you're keeping in constant contact with that counselor. I tie in my advancements of custody arrangement not only to the testing results, but to the counseling and the treatment. So you want to make sure that you keep in contact with the counselor, and if they're not following that course of treatment, that you have some sort of remedies or relief in place in your court's order. Now, to wrap things up, we're gonna talk a little bit about custody arrangements and different ideas, whether the opposing side has the issue or whether your client has the issue. So when you have substance abuse or mental health issues, you're often going to be dealing with no visitation requests, minimal visitation requests, or supervised visitation requests as it relates to those custody cases. And so what we have, so our floor plan here in Missouri is this Siegenthaler case that gives us the floor plan, which basically indicates the non-primary custodial parent will have every other weekend, Friday after school to Monday after school, or to Monday start of school, and then an overnight during the week. So whether it's Wednesday or Thursday overnight. So that's our floor plan. And so you can use that when you're looking at what sort of visitation arrangement you're going to ask the court if the opposing party has the issue. Or, well, let me first start with if your client has the issue. If your client has the issue, you obviously want to maximize the visitation with the children. And so the idea is that you're going to be asking for frequent weekly visitation. And if you can avoid supervised visitation, that's going to be better. Just the stigma of the supervised visitation, it's often difficult to come out of. So if you can avoid it, that's going to be the best approach as far as supervised visitation goes. And one way that I've been able to avoid supervised visitation in some of my alcohol abuse cases is instead of having a supervisor in place, I'll say, hey, let's just use SoberLink in place and just test before and during the visitation. And I've been able to get opposing counsels agree to something like that the SoberLink device will take the place of the supervisor. So if you can do that, that's one way of getting rid of the supervised visitation. You also want to mitigate supervised visitation requests by arguing if the opposing party knew of these issues and allowed your client any kind of unsupervised contact with the children, whether it's for a few hours or whether it's overnights, that's a way to mitigate supervised visitation requests. So you want to make sure you make those arguments. So an example of potential visitation that I like to use, for instance, is I'll have every Tuesday and Thursday night for a couple of hours, so 5 to 7 p.m. or 6 to 8 p.m. And this is, again, in the event that you don't really have a leg up to argue overnight visitation. This is a way to break it down on frequent weekly visits. So in addition to every Tuesday and Thursday night, I'll throw in and ask for every Saturday and Sunday for a larger block of time. So whether it's 4 or 6 hours on each of those days. You may end up with every other Saturday and Sunday rather than every Saturday and Sunday. But if it's your client, advocate for that frequent weekly visitation. And those are some ideas. You also want to make sure that you address holidays and summer visitation in addition to that weekly visitation. So don't forget that, because that will oftentimes, these cases can drag on quite a bit because you got issue, dealing with the issue, and post dealing with the issue. So this can be months to a year or more in having this case. So make sure you're addressing your holidays and summer visitation as well. You want to make sure that you also increase incrementally in your order. So you don't just leave it open-ended, that it's just supervised visitation or minimal visitation without any kind of end. What I like to do is have different phases. So if the client is checking certain boxes in terms of negative testing results and or counseling or treatment and following those recommendations, I will have different phases. So phase 1 may last maybe 2 months, and then so on and so forth, 2 months, 2 months, 2 months. And you want to make sure that you have an end date to this type of restricted visitation. Try not to leave it open-ended because you don't want to have to deal with a modification and going back into court, because that's just more time and money that maybe your client doesn't have. If the opposing party has the issue, obviously if there are safety concerns, you want to make sure that you try to minimize the visitation. You want to make sure that you push for supervised visitation. Oftentimes, family members can be enablers. So if they suggest a family member, you suggest a supervising facility. If your client has the issue, try to push for a family member to be the supervisor. But again, with the opposing party, try to push for the facility. There are cost considerations with a supervising facility. So if it's your client, make sure you walk them through those costs. If it's the opposing side, make sure you give the court the solution of how to get around those costs associated with supervising a facility. So the flip side, if it's the opposing side, maybe you want to leave that open-ended. So if it's a temporary order in terms of visitation, leave the supervised visitation open-ended. Additionally, if you're dealing with alcohol abuse issues, try to tie in a SoberLink type device and then tie in the supervised visitation as well. In the last couple of slides are just examples that you can take with you and have as far as if the opposing side or if your client has these issues. These last 2 slides will give you a couple of examples of different custody arrangements. Now, this just breaks down phase 1 and phase 2, but this, for both the last 2 slides, but you can manipulate these different types of arrangements any way you see fit according to the issues in your case. So this one shows for a period of 2 months. In all likelihood, that would be if your client has that issue, you want to shorten that phase to 2 months. I've had cases where I've had the opposing party have the issue, and it'll read for a period of 6 months. So I'll increase the time before they can jump to that extra phase or that next phase. Additionally, you'll see at the bottom that the periods of possession will revert back and start over at phase 1 if there are any kind of hiccups. So you want to make sure you put that solution into your orders because you don't want to spend the time and money to have to go back into court for any kind of modification or for further temporary orders. So make sure you tie in the relief or the remedy if they have a hiccup or there's a positive test result or they skip out on counseling. And I'll do that all the way through to the very end, to the last phase. I've had, phase 1, 2, 3, and 4, and I'll start it over even after 2 or 3 years worth of testing and counseling. Because again, you want to make sure that they understand that there are consequences to them reverting back, because a lot of these clients will relapse, whether it's your client or the opposing party. So make sure you're addressing those consequences as well.